So please, feedback, because it won't change unless you give us the feedback. So on to tonight, Kizzy Augustin from Pinsent Masons LLP, who I'm sure quite a few of you have met before. The fact that she's back again says that she does a good job and we want her here. But Kizzy's going to give us an overview of some relevant criminal cases, things that have changed and how they can impact us as safety professionals. Also discussing any new emerging changes in the field of health and safety and how they can impact not only us but senior directors. And we're also going to lead, or Kizzy's going to lead, a small interactive session quizzing one of her, can I say, what's the right terms? I won't say a student.
Colleague.
One of her colleagues. Kizzy is going to interrogate him in a little incident investigation interactive session. So if you don't know Kizzy, she's an associate and a solicitor in the regulatory team, specialising particularly, well, she works in the London office, mostly in criminal litigation, defending regulatory investigations, particularly in health and safety related matters, so it is pretty much her speciality. Regularly appears as an advocate in court proceedings and coroner's inquests, and has spoken at many seminars and lectures on the aspect of health and safety and criminal regulatory law. She provides advice on a wide range of health and safety issues to both corporate and commercial clients, with a particular interest in the law relating to directors' health and safety duties, due diligence, and other health and safety matters. So I don't think I need to say much more, but I will, before I hand over to Kizzy, just say if you've got questions during the evening, please put your hand up, and Alex here will have a microphone, and we'll bring the microphone round just so that everybody can hear the question properly. So thank you very much, and I'll hand over to Kizzy.
Thank you very much. Right, hopefully you can all hear me. I've got this roving mic, so I'm hoping you can all hear me at the back. Yeah, good. It's always nice to hear yourself described by someone else, because I couldn't remember what I do sometimes. Right, for those of you that don't know me, I generally do a legal update for IOSH every October. I think this is my 6th year. So I'm either doing something right or they just can't find anybody else to do it. But I thought, for those of you that probably have seen some of my work before, I would do something slightly different this time. New room, new change, it changes as good as the rest. So what I'm planning to do today is first half, probably until about 25 to 7, is to do a rundown of the health and safety cases, issues that I think are important. I've got an overview up. So as I say, part 1, legal update. I won't be talking about corporate manslaughter at great length, but what I will be doing is just showing you where we are now. It's a sort of précis of the cases that have taken place so far. Fees for intervention, we all know what it is. 12 months on, where are we? Proposals for CDM and management of health and safety at work, regs. I'm not going to go into too much detail about that because I understand from Nigel that we might well have a separate session on CDM and the updates on that. Asbestos proposals, first aid at work and coroner's inquest. Again, these are all very recent changes, some of which will be relevant to you, some of which you might just be interested in. So I won't focus too heavily on that. The second part though I think is a bit more interesting, a bit different. I'm planning to do a mock HSE interview. So I don't know how many of you have ever experienced an HSE interview, been part of, had to be a witness for HSE proceedings, but if you have, this will be a refresher. If you haven't, it'll be an eye-opener into what happens in that little room when the HSE inspector comes knocking and says they'd like to speak to you. So, the boring bit for some, or statutory bit for others. This is the legal update. Corporate manslaughter. Most of you, I'm sure, know what corporate manslaughter is. Yeah? Hands up if you don't. It's a bit like school, this. But if you don't know about corporate manslaughter, tell me and I'll give you a quick summary of what it is. No? Everybody knows? Excellent. Right, so we know what corporate manslaughter is. I've filled in here what the elements of corporate manslaughter is. And the main reason corporate manslaughter is so useful is it no longer looks for one person in the company who may have contributed or caused a criminal offence. We're looking at senior management failings. So that could be a number of people. That could be all over the business, that could be within one sector of the business, but really what you need to take away from corporate manslaughter is prosecution. For a prosecution to succeed, they must prove that the way in which the activities of the company are managed or organised, A, caused the person's death, B, amounted to a gross breach of duty of care to the person that died, and that senior management's role and the activities that went on within the senior management regime was a substantial element of the breach concerned. Now, I've put the penalties there, so we know what the penalties are, but it's all about senior management. This is going to become very important. Again, I did say it's a bit like school. When we come to the mock interview, there are going to be things that I will like you to listen out for, because it will come back to you, because I'm going to say, what do you think my colleague did wrong during the interview? So, a bit of a clue, senior management failure. In terms of cases for corporate manslaughter, we have had, up until probably 8 o'clock this morning, I would have said 7. I think we're now on 9 in the space of a few hours, but I've listed the cases for you, so you can go away. This will be on the website, so you will be able to have a look and then follow up for the details. But in a nutshell, we had the first case in 2008, I think, 8 or 9, Cotswolds, which is a case that we did. Does everyone know about Cotswolds? Yeah, geotechnical engineer in the trench, buried. Yeah, okay. That one was the first one. It didn't really test the act because in that case we were dealing with a small company. Cotswolds Geotech, 8 or 9 employees. Managing director was the business, pretty much. He was the only director of the business. And he was prosecuted both in his personal capacity and also as a business. What happened in that case is there were 4 charges, 2 against him personally. So that was gross negligence, manslaughter and Health and Safety at Work Act breaches, section 2, and also corporate manslaughter against the company as well as section 2 for the company. What happened in that case is that all of those offences fell away apart from corporate manslaughter against the company. That stayed and it resulted in a guilty plea to corporate manslaughter and a £385,000 fine, which resulted in the business going out of business. It was such a small business, this fine made them go bust. And the comments made by the judge in this case were, doesn't really matter if the fine is so huge that it makes the company go bust, so be it. The other cases, again, they're quite telling, but not necessarily testing the act still. So we're dealing with small companies. JMW Farms in Northern Ireland, they were fined £187,000 fine for a guilty plea following the death of a farm worker. Lion Steel was a bit more tested, a bit more convoluted in terms of the proceedings. Important thing to take away from that case is that a number of directors, finance director, I think health and safety director, and another director, were personally prosecuted as well as Lion Steel, the business. Again, relatively small company, we're talking about 140 employees. So normally corporate manslaughter is meant to test the bigger organisations, the likes of Balfour Beatty, the likes of Transco, those sorts of big organisations where it would be near impossible to find one person within the business. But still, the CPS are still pursuing these small companies. So what's going on? In Lion Steel, it was a very similar circumstance to Cotswolds, where it was a load of charges against the directors personally and the corporate, and what ended up happening is there was a bit of negotiation, a bit of legal argument, and what stayed was the corporate manslaughter charge. So you start to see a pattern where prosecution will charge corporate manslaughter along with health and safety offences, and possibly along with some criminal manslaughter charges, in the hope that a company will say, we don't want our guys to go to prison, so what we'll do is we'll plead to corporate manslaughter, because that's the corporate offence, if you let our guys go. And that's pretty much what happened in Lion Steel. PS and JE Ward, again, another small company. The remaining cases are still going through the court. So you can see, only 3 prosecutions been concluded since 2008. And then what happened last year is we had a run of cases being brought towards the latter part of the year. PS and JE Ward, nursery pursued for corporate manslaughter, an employee was electrocuted during his duties. M&S Mining, that was a site owner was prosecuted, so we were not talking about directors. It's normally directors we're talking about when they're pursued personally. In that case, it was a site manager, site owner, who was pursued in his personal capacity for manslaughter and health and safety offences. And in that case, 4 miners died because they were sent down into a mine shaft which was it was actually flooded, and all 4 miners died. So that's still ongoing. Prince's Sporting Club, that was a young girl who fell from a banana boat during birthday celebrations. And the driver of the banana boat, so I think it was actually towing the banana boat around the water, didn't realise that the girl had fallen off the banana boat and actually ran over her. So, sorry, it's a bit gruesome. This is health and safety, I'm afraid. But yeah, he ran over her, and he has been pursued in his personal capacity as well as the business. Finally, Mobile Sweepers, Rainbow Limited. That was an employee who died from crush injuries. I think he was, the back of the truck fell on him, and it was not really known whether he was being supervised or whether he'd been trained correctly. So again, director personally pursued as well as the business. All of these cases were ongoing. They're still ongoing. We haven't had conclusion for each of them. I said there have been others. That was up until yesterday. This morning, a colleague of mine from Northern Ireland texted me and said one of a big organisation in Northern Ireland called J. Murphy, I think, just been charged with corporate manslaughter. So we're now on number 8, and number 9, which I can inform about, is a case of mine, which was charged a couple of days ago, and that is a Scottish case where there was an explosion. A pressure vessel exploded, and the business are being pursued for corporate manslaughter because they failed to ensure that the machinery was being inspected on time, and as a result it was a fault, and one of their employees was unfortunately suffered fatal injury. In terms of corporate manslaughter, as I said, since 2008 this Act came into force, and we're now in 2013 with 3 prosecutions completed. We've got, however, 56, and it might be more now, but 56 open corporate manslaughter investigations. What I would say to you guys is, don't think because I said there's only 3 prosecutions that it's not going to affect me. Just, don't think that. What I would say is to consider it. It's a real possibility that corporates are now going to be looked at for corporate manslaughter a lot more readily than they have been in the past. And the reason for that is because it normally takes about 4 years for these investigations to start and conclude by the police and the HSE. So we're getting to that stage where the 4-year period, 5-year period is coming up, so they're now looking to charge people, and we're seeing that happening now. In fact, I was on a case today where they are looking to charge the company with corporate manslaughter because, again, it was a very serious fatality, and they're looking at senior management failings, failing to supervise subcontractors, failure to select subcontractors. Those are the sorts of issues we're talking about when we're looking at senior management failings. Fees for intervention. Lovely. Right. Show of hands, how many people have either working for a corporation who has experienced a fees for intervention notice or has had some other interaction with a fee? Well, a few. What's the experience? Good? Bad? Say bad because I don't like HSC, but go on. What's the feedback? Good? Anyone else who's had a fee? There?
Yeah, the company basically hadn't got anything in place, and retrospectively put it in place,
Mm-hmm.
and quite honestly deserved it.
Okay. All right. Remember, this is being recorded now. Anyone else got comments in terms of the approach of the HSE or the way in which the fee was dealt with? Yeah.
One was they popped into a client of mine and said they finished early somewhere else, so obviously looking to make some money. So they nipped in there for like 2 hours, threw some grenades about, and then left, so they've got to go on somewhere else. And then put in a letter with about 4 or 5 points in it, which obviously 3 turned out not to be valid, but 2 did. So it was kind of like, oh, we're passing the door, we might as well make the time up. Whereas I suggest before this existing situation, they might have gone and had a cup or something.
Can I just say that I'm very pleased to hear that I am not the only HSE basher in the room. I have read feedback forms in the past. I know that there have been a couple that have said, why do you bash the HSE so much? They're doing their job. And fair enough, they are actually doing their job. Whatever I say, please note, it stays in this room. outside of this room, I'm not an HSE basher. We all know, we've all got our respective jobs to play, and to be honest, with fees for intervention, the purpose of them are pretty valid. If they're going on site and they're finding a fault with a company or the way in which they're managing something, or there is a health and safety failing on site, of course they should be pointing that out to people. I've put on here what the elements are of fees for intervention. Material breach is needed. Again, we still don't know what the definition of a material breach is, but I understand it's in the eye of the HSE inspector, and they will decide what a material breach is. We know it costs £124 an hour, and there's 30 days to pay the notice. Appeals process, we now do have a specified appeals process, and I was concerned prior to the whole 12 months going past whether or not there would be a proper appeals process and whether or not it would be used. What we can see 12 months on is that invoices are apparently being quality checked by principal inspectors, which is fantastic. It's great news that they're actually checking what their guys are doing. However, in the last 12 months, I'll say up till June 2012, I've got some figures for you. And you judge for yourself whether you think FIFI has been, by the way, FIFI is fees for intervention, it's just my pet name for it. You judge whether it's been successful or not. So by the end of June 2013, the HSE had generated £2.5 million by way of these notices. Most of the invoices were for approximately 500 quid. So initially I was saying, let's worry about it, could run into thousands. Most of them are for £500, but what you will probably start to see is that when you start getting the specialist inspectors coming down to site and having expertise and having to discuss things, £124 an hour can start to rack up. So that was always a concern of mine. In terms of stats, 145 queries were raised, so that's the first stage. Remember the appeal process? You've got the query stage where you can just ring up and say, I don't agree. You've got the next stage, stage 2, which is you write in and say, these are the reasons why I don't think we should have a fees for intervention notice. And the third stage, which it goes to an independent panel, which basically is 2 HSE inspectors and 1 person from industry. You can see there from the stats, first stage appeal, there's been 2 cases, both found in favour of the HSE. Surprise, surprise. Second stage appeal has not yet been heard. It may well have done now, but when I was doing these slides, it hadn't yet been heard. And we're 12 months down the line. And so we've only got 3 real appeals. So how successful has FIFI been? I think most people are just rolling over and paying 500 quid. If it's 500 quid, most people will pay it. What I've said in previous sessions is that it's worth considering the effect of accepting a fees for intervention notice. Yes, it's £500, it's not a lot of money for most businesses, they just want to get rid of it. What it does actually mean though is it's an acceptance that there is a failing, and therefore it's a potential acceptance that the business has committed an offence. So there's nothing to stop the HSE just saying, you've accepted it, here you go, sign the notice, you've paid our fee, we're now prosecuting you for it. That's a possibility. So it's just worth considering. It's definitely a consideration for the business. And there I've put some more figures in terms of unannounced HSE visits. Majority of these visits are by way of tip-off. Yep, so you'll get employees or customers, depending on the business, making a phone call and just saying, look, I'm worried about this, can you come and have a look? And the HSE love that because it means that the public are doing their job for them. Again, you can have a look at this at a later date. What you'll all know about is that September, just gone, was the month of sweepstake. It was for the HSE to then descend on mostly construction sites, and we're looking for things like failings to do with dusts, so prime target asbestos, and also working at height was certainly a focus for them. As I said, I'm not going to focus on CDM. You'll all know about proposals for CDM. I'm sure you've all been beaten up to death with what CDM might mean for those of you in construction, like Alex. But I think we're definitely going to talk at length about what it will mean in terms of the proposals and whether they're going to go through, and whether the consultation was successful, etc., etc. So I'm not going to go on at length about that. Management of health and safety at work regs. I've listed what the changes are. There is a new replacement of the ACOPS and guidance, and there is a suite of guidance documents to look at. Best place to look for these, HSE website. See, I do like the HSE. They do good things. They're all on the website. HSE 65 is pretty good, pretty comprehensive, and talks about things like the risk assessment and how you manage health and safety for businesses. Asbestos. Again, I've tried to list everything so that if you were to look at this at a later date, you could easily read this. There are proposals to revise the existing ACOPs for the asbestos regs. It's basically bringing two ACOPs in line with each other. So it's taking in line with the 2006 asbestos regs and the 2012 asbestos regs, and bringing everything in line, making everything about the HSE documents are really about making things simple. So they're going to do that. It was clearly done in response to Ofsted's review of health and safety legislation. And as I said, it's about making it easier for employers to understand their obligations to employees. I'll put a list of proposed revisions. I think consultation stopped now, but it's set for publication in December. Whether that happens, I'm not sure yet. First aid at work, again, there's a list of what's happened to the first aid at work, health and safety first aid regs, the guidance, applicable from the 1st of October, removes the requirement for the HSE to approve training and qualifications for those who are appointed persons. So those are the appointed first aiders in the business. Now some people think that's a big mistake. Whether it is or not, you know, again, it's a suck up and see type attitude. Let's see whether it has significant effect on the amount of accidents or responses to accidents when you've got an appointed person in the business. And I've just chucked in coroner's inquest because there have been some changes to coroner's inquest. Again, I don't know how much any of you would have to do with a coroner's inquest, but the changes are primarily for the likes of me and coroner staff. It's not necessarily for people that would take part as part of an inquest. But if you're interested, there have been some changes to the coroner's rules, mainly to do with the amount of time that should pass between the opening of an inquest and listing the actual inquest hearing. There's an aim to conclude all inquests by 6 months. I doubt that's going to happen. I don't think I've yet had, apart from a very simple coroner's inquest, I've not yet had one that's concluded within 6 months. Disclosure, again, it's all about providing information to companies who are involved in, so they're called interested parties, so anyone who is interested in the proceedings, who have, you know, an interest or a relevance in the proceedings, they're allowed to have those documents disclosed to them, and the coroner should be providing those documents as soon as reasonably practicable. Evidence, again, like court proceedings, there used to be there's things called special measures. Those are for people who are young and who are vulnerable and who want to give evidence behind a screen like that. They're allowing that to happen in coroner's inquest. So again, if you're interested in those sorts of things, I've listed them there for you. Probably the most important thing for businesses is the Rule 43 report. Rule 43 reports are really the coroner's attempt to let the business know that you should be doing something so that it avoids this incident happening again. Much like an incident report, what the coroner will do is say, look, I'm putting some recommendations in a Rule 43 report. Here you go, you've got 56 days to let me know whether you're going to follow my recommendations or whether you can justify not following the recommendations. It used to be an option for the coroner, it's now a duty for the coroner to have these Rule 43 reports, if she feels there is a good reason to do so. Right, so that's kind of a whistle-stop tour with things that are interesting in the law. I'm going to take Q&As if you've got them on the legislation bit. Otherwise, we can go straight on to the mock interview. Has anyone got questions on legislation? Yeah.
Just a quick thing on the HSE not approving first aid training providers. What was the rationale behind that? Was it just a cost-saving exercise, or
you're asking the wrong person because I'm completely sceptical.
Has it ever been explained why that was brought in?
Well, it has. Has it? It hasn't. I think justification is that it's felt that by way of people using competent people and the amount of training that's available for first aiders if you want to become an appointed person that's out there, they are satisfied that anyone that carries out or undertakes one of those courses is going to be competent. My view, being a sceptic, I think it's just because they don't have the necessary manpower to be able to approve these things. I think that they need the resource elsewhere, and they're not thinking about things like first aid, which sometimes can get pushed to the back of the queue when you're thinking of things like fees for intervention, when you're thinking about asbestos inspections, when you're thinking about, you know, those are the more sexy subjects for the HSE at the moment.
Thank you.
Anyone? Yeah.
Hi, Kizzy.
Just a review. Go on.
With the Enterprise and Regulatory Reform Act,
Yep.
that's changing people making claims against their employer.
Yep.
Are you seeing that having an impact at the moment?
Not yet. I think it's too soon to tell. The good thing, I suppose, the good thing for employers, I think, in fact, it is good for employers, is that you can no longer just run on the back of a health and safety prosecution. It's no longer about, if there's been a health and safety prosecution that's been proved, of course there's been negligence, so I'm therefore claiming. That used to be the case. What Sue's talking about is there's been a change to the law in that it's no longer about strict liability. If you're going to bring a civil claim against an employer or another party, you've got to prove negligence. So it's now a separate thing to the health and safety prosecution, if there has been a prosecution. I think it's too soon to tell because the change in the law is so new. I think there's always been claims. In my experience, I've always had, on the back of a HSE prosecution, there's always been a claim stuck in, whether it's frivolous or not. So I think you'll actually see less claims because those frivolous claims are going to be chucked out at the very first opportunity. You're going to have to prove negligence, and very often, you know, most businesses are quite sensible. I don't think I've got any clients, and I'm sure there aren't any of you in here who deliberately fall foul of the law or, you know, run businesses that are, you know, cutting corners at every angle. So generally speaking, you won't get businesses that are deliberately negligent. So I think you'll find the effect of the change in the law is going to be less claims, but the more serious stuff will go through a lot quicker. Yeah.
I was just wondering why investigations take as long as 4 years, and surely that must have some impact on how easy it is then going to be to prosecute.
Very good question. In answer to that question, why does it take so long? Again, I'm answering as a sceptic. I am not any part of the HSE, as you know. The answer is because they're bloody lazy. But the real answer is they don't have manpower. They have complained that there isn't enough resource in order to pursue investigations. They're very quick when there's an incident to get somebody down. When it comes to following through and getting witness statements and actually investigating the nuts and bolts of potential offences, they're running short of people to do that because they have, you know, back a year ago, they moved a lot of the resource from investigations to inspections. And there was more focus on fees for intervention inspections and the random inspections because the HSE needed to generate, was it 48 million? 48 million in a year. So the focus was different. So investigations have always taken a long time. What's happened is now, in terms of guidance, the HSE have been provided with guidance that they should be taking no longer than 3 years from start of incident to decision to prosecute. Whether they stick to that is another matter, but that's the guide at the moment. But yeah, you're right, it takes way too long for inspections to take place, and it certainly does have an effect on the recollection of witnesses, and whether or not it's even in the public interest to prosecute 4 years later. So, really good point.
Some of them die in the meantime as well.
Could I just come back on that point? In the past, when it's been 4 years for a prosecution, that's quite often because it was the case that you had to have the inquest, and the inquest had to be concluded before charges could be laid.
And that's no longer the case.
And if the inquest takes 2 years, there's an automatic 2-year delay. So I think to answer this question about the 4-year delay, the requirement for the inquest to take place within 6 months should speed things up
Hopefully
considerably.
so. Yeah.
And it's not HSE necessarily sitting on their backsides, it's is the fact
You're not from the HSE, are you?
No, I'm not.
Yeah, no, as I say, that was a very flippant comment, as I said, just for this room. But more often than not, I mean, even when it's not a fatality, we have significant delays in the conduct of investigations. I've had a number of matters which haven't been fatalities, which can take 2-3 years. And to be honest, if it's a normal slip and trip that they just decided to investigate and want to prosecute, to me, if it's quite straightforward, it shouldn't be taking 2-3 years for that prosecution to come to fruition. But it still does, and I still say there's a significant issue in relation to resource, and I think they're now trying to rectify that. Okay, probably last one, and then we'll crack on with...
Are there any plans for other regulators to charge for interventions, people like the Office of Rail Regulators and things like that?
There is talk about it. There has been talk for some time. So no, not just ORR, but local authorities as well. Will it happen? From one side, you can see, well, why not? Because if the HSE could do it, why can't other regulators do it? I think some of them are running a bit shy of doing that because it's a lot more paperwork. It's the same issues that the HSE have with enforcing fees for intervention. I'm not sure local authorities, again, they've even got less money to spend on this. I'm not sure they have the appetite to do it. But there is still talk about it behind the scenes. They are still consulting about whether or not the HSE can do it on behalf of the local authority as well as their own patch. But yeah, we just have to wait and see. Good? Right, I am going to get on with the next stage of today. Are you all still with me? I hope so. All right. I've done this primarily because a lot of people in their feedback forms have said, we'd like to know a bit more about accident investigation. I could talk to you for an hour about accident investigation, but I'm not going to. What I'm going to do is just highlight some of the main issues in relation to accident investigation. RIDDOR, we all know what RIDDOR is. We all know in what circumstances we have to report incident. And I've listed it there. What I want to highlight, though, is in terms of accident investigation, why are RIDDOR reports significant? Most people think, okay, there's been an accident on site, we're just going to report what happened, we're going to say what happened. Important thing is, in the form, it does say, describe what happened and give us as much detail as you can. For instance, events that led to the incident, that's fine. Part played by any people, that's fine, just identify who's involved. And any action that has since been taken to prevent a similar incident. That's the bit I'm concerned about, because as much as people want to give us a full account of what's happened, that bit that says, tell us what action has been taken since incident, if you start saying, well, since incident we've changed our RAMs, we've changed our lifting policies, we've changed our induction policies, you start putting things like that down, that's again a potential admission that things were wrong before. So what the HSE could do is say, well, thanks very much for your RIDDOR report, very full and frank and lovely for us. What we're going to do is we're going to prosecute you for those potential failings, thanks. And then what do? You can't come back from it because it's already been put in the RIDDOR form. So that's something to look out for when filling in a RIDDOR form for yourselves. Duty to investigate accidents. Well, there isn't an inherent duty to investigate accidents, but what the Management of Health and Safety at Work reg says is that there is a legal duty to monitor and review. And what they mean by monitor and review is things like looking into the effective planning, organisation and control of the business and what preventative measures have been put in place. So essentially what we're talking about is investigation. We're talking about after an incident, what happens thereafter. Does somebody in the business investigate what happened, why it happened, how it happened, and lessons learned thereafter? Once you've prepared a report such as the one I just described, I've put there, can the report be covered by privilege? Everyone know what privilege is? Yeah? Okay. Right, we've said no retrospective documents. So your RAMs that was prepared a year before the project was completed is not going to be privileged. However, what might be privileged is if you have an incident and you ring up a lawyer and say, oh, I'm worried about this, I think it might result in civil claim against the company or might be prosecuted, what would normally happen is a legal person would say, well, okay, I'm going to advise you on your potential liabilities, and in order to do so, I'd like you to carry out an investigation, please. And I've normally put that all in writing. And what that means is if I then request you or someone else in the business to conduct an investigation and or to draft a report detailing what happened and why it happened, how it happened, and lessons learned, I can use that information to advise you and or the business on whether or not there are likely to be any implications, legal implications. So privilege is all about having the dominant purpose to obtain legal advice. So this is the reason why the report will be done, primary reason. To obtain legal advice in contemplation of legal proceedings. As long as you've got those bits, these elements fulfilled, you may be able to attract privilege to the report. Privilege means that, so if you've got a report and it's privileged in the way that I've just said, you don't have to disclose it to third parties. That includes police, HSE, coroner, or personal injury claimants. It includes things like solicitor-client communications, so those emails that I send out to clients, those are privileged because they're all about me providing legal advice. Third-party communications, again, potentially with insurers, for example. Those might be privileged. If I then share the incident report with an insurer, that may be protected by privilege. It's very easy to waive privilege because if you start forwarding on emails that have been headed privileged and confidential, but the dominant purpose, so the dominant purpose was to obtain legal advice in contemplation of legal proceedings, if that goes, and the main purpose is actually we just want the business to learn lessons, we don't want this to happen again, you may be potentially waiving privilege. So that's something to definitely think about. And tips for after an accident, well, I've listed them there. Get legal advice, appoint a core incident team, and someone that can be the point of contact for the enforcing authority, whether it be HSE, local authority, ORR, whoever. Contact your insurers, because you've got a duty to do so. Secure channels of communication, and that means checking that emails are not just being sent willy-nilly. You've got a core team who send emails to each other. Using verbal methods, so having team meetings rather than memos going out everywhere. Consider the powers of the police and the HSE/local authority and what interviewee rights might be. I think I've spoken about that before. Oh, what's happened to my stuff? There it is. Practical tips, lastly. Think carefully before handing over documents. That includes things like HSE requesting documentation. Remember, just copies, no originals going out. Check the type of interview requested. And again, I think I've spoken before about the different types of interviews, but you've got voluntary, which is the Section 9, normally the statement form. Section 20, which is the statutory powers of the HSE, where they can compel you to answer questions. And PACE, which is the interview under caution, like a police interview. Asking for copies of statements after an interview, probably quite important. 9 times out of 10 you won't get them, but it's worth asking for them. And consider everyone who may read your report. So if, for example, the incident report is not privileged, so if we're in a different situation when you haven't attracted privilege to a report and it's been drafted, think about who might read that. That report is potentially disclosable to all of these people. What you might want to do is, if you're not attracting privilege to a document like that, is avoiding any clear admissions of liability in that document. Okay, mock interview. Come on, Joe. Come and show your stuff. Right, I have devised a situation where we're talking about a construction company here, really, but I'll read out the scenario. I've left out the pertinent facts so that you can read them, and then you can have a listen to the interview as it goes on. So, we've got a company called Shortcut Construction Limited. It's in the name, see how clever I am? Construction firm have been working on Transrail, which is a large rail infrastructure project in North London. Started in January 2013. In June of this year, we've got someone called Bob Johnson, who was assisting Alan Spark, the project electrician, who's helping him to install signalling boxes along the rail line. Jenny Bloggs was the site foreman on the day. Foreman's duties, amongst other things, is to supervise new workers, and Bob is one of those new workers because he joined a week previous. Alan asked Bob if he would just help him finish off the wiring on the last signal box to speed things up a bit, so that they could meet the project phase deadline. Bob had no specific electrics training. Alan said, well, let me just check with Jenny. He rings Jenny up, and Jenny's not on site, which she should be, but she's not on site because she's dealing with another site nearby, in northwest London, and in fact she's not been to the Transrail site in 5 days. Jenny knew that Bob wasn't a trained electrician, so she thought, well, let's check with our Health and Safety Director before I say yes. And the Health and Safety Director's name is Chris. Chris's view was, Jenny, you know that the board are getting grilled about these, the project being behind schedule, and I can do without another 2-hour meeting, getting on my back about this. It's all hands to the pump. New workers need to earn their day's pay. We need to meet our cost target. Don't worry, Alan will look after all of the newbies. Anyway, most of them don't understand anyway because they're Polish and they don't speak English. Jenny, though uncomfortable, allowed Bob to assist with the electrics work. As Bob was helping Alan install the wiring, he mixed up a red and green wire and was electrocuted, resulting in fatal injuries. The CEO of Shortcut asked Chris to conduct an internal investigation and to produce a report on the incident, which he did complete. One part of Chris's report stated, whilst the competency of the staff has fallen under question, the company has been under increased pressure to meet timescales set by Transrail. This resulted in a lack of comprehensive training and supervision on numerous occasions. This is not the first incident involving a lack of supervision, and these issues do not appear to have been addressed at a senior level. So questions for you to look out for is, what does Chris, say hello Chris.
Hello.
What does Chris do wrong in the interview? And what advice would you give to Chris if you were sitting where he is? Right. Off we go. Oh, and by the way, this is a caveat. This is not really how it happened, but I'm actually sitting with a HSC and a police hat on. So it's very clever of me, but it wouldn't necessarily happen in this way. Okay. Chris.
Hello.
I've invited you here for interview to answer questions in relation to the fatal incident at Transrail site in North London on the 1st of June. I suspect that you may have committed the offence of corporate manslaughter and or committed a number of health and safety offences. I'll now caution you. You do not have to say anything, but it may harm your defence if you do not mention now something which you later rely on in court. Anything you do say may be recorded and given in evidence. Do you understand that caution?
Yeah, I think so. I'm happy to carry on.
Great. Okay, well, I'm here to investigate a criminal matter. You've got the right to have legal advice, but to be honest with you, I assume you're happy to cooperate with our investigation, so you don't need any of that. And if you did request a solicitor, I'd have to put you in the cell while you wait for them to come, and you don't want all of that, do you?
No, I don't think it's necessary. I've done nothing wrong. I need to get home to my kids anyway.
Excellent. All right, let's crack on. Could you give me an account of events that occurred on the day of the incident, please?
Well, it's simple, really. The team were working on a section of Transrail, and the labourers usually get involved in helping dig the trenches to run the cables to the signal boxes. Mm-hmm. I think Bob had joined us a week or so before the incident, and I gave him his training and induction, which included him giving him the health and safety talk, etc., and the health and safety leaflets on safety at work.
Right, and did Bob sign the induction sheet to confirm that he read and understood the health and safety documentation?
I'm not sure. I'm pretty sure he must have done, but I don't keep every single piece of paper in the office. Bob was pretty sensible, he understood things. Bob was giving Alan a hand with the signal box. Whilst attaching the cables to a signal box, he got an electric shock from one of the cables. If he didn't know what he was doing, he shouldn't have been helping out. He should have told Alan that he didn't quite understand what to do, and in fact, Jenny should have been keeping a closer eye on things on site.
All right, so it's Jenny's fault, is it?
Yeah.
Right. Okay. Can you tell me a bit about the conduct of the company in relation to health and safety policy?
We follow all the government and HSC guidance that tells us to do tells us everything about telling our employees not to bend over when they pick up boxes and things like that. We can't give everyone specific training on every aspect of every job on a work site. We've got deadlines to meet, and often workers only stay for a few weeks at a time, so to train everyone on everything would cost the company too much time and money. It's not realistic, no other contractors do it, otherwise they wouldn't be making a profit, would they? Anyway, it's just guidance. I'm not breaking the law if I don't follow the guidance, am I?
I certainly can't comment on that, Chris. Did you carry out an investigation of the incident?
Yes, I did. I brought a copy of the report for you.
Brilliant, thank you very much. Oh, it's quite lengthy, isn't it? Okay, let's have a quick read of that. I note that you say here you've got concerns about lack of supervision and training of employees, and there have been similar incidents for the company. Can you tell me a bit more about that?
Well, there's been a couple of incidents where the site foreman hasn't been on site while a slip and trip type incident has occurred, and we're aware of our own competency criteria needs updating. For example, I know we don't have a complete record of CSCS cards held by our permanent and agency staff. We also have a problem translating our documents into Polish and Romanian, so some of our agency staff can understand our policies and procedures. Anyway, I'm sure the likes of larger construction outfits like Lang, O'Malley and Mason have the same issues. These are industry-wide issues and not just applicable to shortcut construction.
Right, okay. And how much does the board actually know about the company's health and safety incidents and matters?
Well, they generally leave me to get on with it, other than the odd thing here and there. We've never had anyone stupid enough to hurt themselves seriously like this, and we've had hundreds of workers working on Transrail. I report to the board at meetings, and if there's been any incidents, which there's been very few, I ask them for some cash if the government say I need to spend something on new equipment, for example, and the board usually leave me to order what I want in relation to protective equipment, because they know you've got to have it, and all the money they spend on that is written in the minutes. But as a business, we're encouraged to save money where we can.
So you've got quite a lot of decision-making ability within the business.
Yeah.
I see. Can you tell me a bit more about induction at Shortcut?
Sure. Well, I ask all the new recruits what experience they've had and what sort of jobs they've worked on. If they've done something, I don't waste time training them on it and just let them get on with it. It costs money to send them on these day courses. If they say they've never worked with forklift trucks, for example, I'll find someone else to do that work, and then maybe ask one of the more experienced guys to show them how the trucks work for a later occasion, and that way you don't need to spend money on unnecessary external training.
So have you got a sign-off sheet for any of these internal sessions or toolbox talks?
Nah, once they're done, they're done.
Right. We spoke about Jenny earlier. Has she got any formal qualifications as a foreman?
I think she's got some relevant experience. I remember appointing her myself. But what they don't teach you on these courses is how to get a project completed on time.
And so therefore, how do you satisfy yourself that the project is being supervised properly?
Well, I like to walk around the site once a week or so, and I always tell people if they're not wearing their PPE, safety hats or safety goggles if they're drilling or whatever. And I'm always getting stick from the guys about it, but I just have a laugh with them and tell them, I know it's a waste of time, but it's the law. I also have a weekly meeting with Jen, and I ask her if she's got any issues with the new recruits and how we're looking on time targets. She does a good job looking after the staff, as I've said, so I know the project is in good hands safety-wise, but I don't think she pushes them hard enough in terms of speed of work.
And Bob, what about his qualifications?
I don't think he had a specific trade. He was just a general labourer. Though we did send him on a day-long health and safety course with Safe at Work Limited. The majority of his skills were acquired from practical experience, I think.
And did Bob have any specific health and safety guidance?
Well, we get all the new recruits to sign the forms with the guidance attached to cover our backs. I've put the original forms in with a copy of my internal investigation report.
All right, so I've got those forms here.
Yeah, they're at the back.
Right, I'll have a look at those a bit later. And just finally, what about the other workers? I understand you've got a number of Polish workers. Do you make sure they're given the same set of conditions in English?
Well, they get the same as everyone else, and they usually ask their mates if they don't understand a word or two.
Right, okay. Well, thank you for that. It's been most helpful. I note that there are some issues in relation to selection of workers. Also potentially your own staff who are not necessarily qualified to do the roles in which you put them in. There are issues to do with the workers that you've got who are not English speaking, and generally the policies don't seem to have been appreciated or dealt with at a senior level, do they?
Well, it's been the same since the recession. We're forced to hire cheap labour and spend less on training because big government work won't pay as much anymore, but they still want it delivered in ridiculous timescales. And all the construction firms operate like us, so why should we be treated any different?
So it's a bit of, if someone else does it, it's okay.
If it's the industry standard, yeah.
Thank you very much, Chris.
Thank you.
Good. All right. So, I note the time. Do a bit of Q&A, but are you guys still all right to hang on for 5 minutes? Do a bit of Q&A? Good. All right. So, questions. Oh, sorry. Questions. What did Chris do wrong? It's not a one-word answer. It's not a one-word answer. But let's just see. Go around the room. Let's just see if everyone can, shout out what you thought he did wrong.
He waived his right to legal advice straight away.
Absolutely, absolutely.
You cleverly cajoled him and tricked him.
Just a clever agency inspector. Yeah. Point is, waived legal. He didn't take up the advice of getting a lawyer present. If it's a normal sort of police interview or an interview under caution, you do have a right to have a lawyer present. Alternatively, if it's one of those voluntary or Section 20 interviews, you've got a right to have someone else present. Not a lawyer, but it would be a colleague or someone to sit in to support you. So really, the person interviewing you, or whoever it would be, should be advising you of that. Take them up on that opportunity, even if it means delay. Very often, you're not going to be put in a cell while you're waiting for someone to come with you. Normally speaking, these are interviews by appointment, so you can go along with the person that you would have sitting, supporting you. Anything else?
I've got a list of 10 things on my sheet.
You can't be the only one answering. They must have been listening.
Shut up.
Go on.
He should go to jail, though.
He just didn't sound certain about anything.
Yeah. He wasn't clued up enough. Again, point there to be made is that Chris is meant to be a member of the board. Comes back to the issue I said about senior management. He is a member of senior management. He could well be pursued in his personal capacity as Senior Health and Safety Director. And again, he didn't seem to know really what the policies were. He didn't really explain how the board deals with health and safety in terms of having it top of the agenda. And there is guidance to talk about, the board putting health and safety at the top of the agenda, and they've got to show that. The best way to do that is to stick it in the minutes. If you have a meeting, talk about health and safety, talk about the riddles, talk about the near misses, and how best to deal with those. So yeah, you're right. He didn't bring that up.
Don't say I'm not sure, but you're better off saying I don't know and leaving it at that.
Yeah, good point. That's a practical point. If you don't know something, don't be afraid to say I don't know. Very often people will just want to say something because they feel they've got to say something. That's just the pressure of interview environment. Yeah. Yeah.
Well, I spent many years prosecuting local authority for legal purposes, and when I invited them to take interviews, they never even turned up. They just wanted to question us advice and give the answers advice. And I've rarely had people working that my advice to be not bother turning up.
It's a good point. It's a very, very good point. I've done both, like you. I've done the prosecuting and I've done the defence. To be honest with you, when it's a company being invited for interview, so normally the wording is we invite a representative of X committee to come and answer questions. Very often you will not get someone from the business putting themselves forward as a representative of the business to answer questions in the hot seat. It's much more manageable if the company answer questions in a controlled, managed way, and the best way to do that is by written representations. Yeah, and very often people will just ask for a list of questions, or can you give me a scope of what you want to talk about. So it's just a way of managing the disclosure of information. it slows the process down. I mean, it depends on which side you're coming from. From a prosecuting point of view, you don't get the answers as quickly as you want them. You then have to ask follow-up questions, so it does draw the process out. From a business perspective, it's much better. It's a much better way of managing the disclosure of information. You can put as much information as you want in your representations, but it's just a better way of managing it rather than having one person on behalf of the business answering questions. What else did Chris do wrong?
He was quick to blame Jenny for the incident.
Yeah, never throw your employees or your colleagues under the bus. Rookie mistake. To be fair, yes, Jenny may have committed an offence or has failed in her duty as site foreman, but ultimately the buck probably stops with her employers and whether or not she was trained adequately to act as a site foreman. They knew she wasn't qualified to be a site foreman, so actually by saying that doesn't necessarily help Chris or the business. In fact, it probably just shows that there's been failings at a senior level to make sure that their staff have got qualifications.
Never give free information, of course.
Yep. Only answer the questions that you're asked. Don't necessarily start verbal diarrhea and start explaining things or justifying things when you actually don't have to. Questions asked, answer that question. Never show up to?
Always show up with empty pockets.
With empty pockets? Why, in case you get sent down to the cell? Oh, yeah, no, you're right. So, a point following on from that is, if you're turning up to an interview and you're bringing stuff with you, for example, documents, accident report, you see you handed over the accident report without question, volunteered that, volunteered certain company forms. Best way to do that is to wait and provide those at a later date. Don't feel pressure to just hand over documentation as part of the interview process. It's normally managed probably at a more senior level and it can be provided at a later date.
He was also answering questions about detail, about procedures and forms people filled in, and things like that, which he wouldn't really expect him to know off the cuff, and he was giving off the cuff answers which were probably wrong anyway, so he was being far too liberal and casual in his response.
Absolutely, absolutely right. Again, it's only answering things within the scope of your own knowledge. If you're invited in your personal capacity, answer things that you know about, not what you think you know about or what somebody else has told you. It's just with it, whatever's in the scope of your own knowledge. One important thing that happened at the beginning is I told Chris that I was interviewing him because I suspected that he had committed the offence of corporate manslaughter. What's wrong with that?
He's not a corporation.
He's not a corporation. Exactly. He's not the corporation. You cannot. One, the police have done this, and I've had a case where they did this by accident, but they arrested somebody on suspicion of corporate manslaughter. That could potentially invalidate the whole of their investigation because they started it wrong. You can't actually arrest someone on suspicion of committing corporate manslaughter. So it would have to be either we are arresting you or we're questioning you on suspicion of gross negligence manslaughter, which is an individual offence, or we'd like to speak to you about potential health and safety failings and possibly senior management failings in relation to corporate manslaughter. If it's phrased that way, then that's okay. But it's not corporate manslaughter in an individual capacity because it can't happen. Anything else? Not sure what else there is next. Cool.
He admitted total lack of record keeping.
Yes, yeah, made some pretty serious admissions in relation to failings. Let's just see if I've missed anything. Go on, Anne, have you got any other?
As he admitted that he'd been given a budget, he was like saying he's senior manager, but in terms of health and safety, it should be led by the manager. The culture, he demonstrated that the culture of the company in relation to health and safety was so poor, and which the rest of the team just followed his lead and said it was, so flippant, it's bad. His attitude.
So it's a decision made by him.
Yeah.
Why that's important is because the individual health and safety offence for senior managers and directors talks about failings committed with the consent, connivance or neglect of the director or senior manager. So there could be a potential prosecution under Section 37 of the Health and Safety at Work Act, which is all about, in this case it would be probably your consent to failings taking place under your nose. But Yeah, that's right. Something on the back of that, one really important point, is that Chris talked about budget issues. He talked about keeping to time scale. He talked about potentially cutting corners to save the fact that they wanted the project to finish on time. Now, if he was prosecuted or the business was prosecuted and that all came out, what that could mean is that that would be used as an aggravating feature and could heighten the amount of a fine, because it said that you're putting profit before safety. And he's pretty much admitted that in his interview. And that was the first opportunity you could to give an account, so that would pretty much stick. Anything else? Go on. Yeah, sorry, you instructed.
If he called for a solicitor, would he be advised question by question? What would actually happen?
Right, if it was one of those interviews that he could have a lawyer present, what would happen is, in terms of practical measures, the lawyer and Chris would go out of the room and have a private consultation. Solicitor, if it was me, I would be asking for things like, can I have a look at whatever documentation you're planning to put to Chris in interview? So can I have a look at photographs that you want to put to him, or method statements or whatever? Can I have a look at that? Can you give me a disclosure statement? And what that means is, can you tell me what's happened in your investigation so far that you want to question Chris about? So it's getting a bit of knowledge beforehand. I can then advise Chris on how best to answer questions, and that may well be you answer no questions. You've got a right to sit there and say absolutely nothing. That's the right of silence. Or answering questions, question by question. Now, so it's not receiving advice question by question, but when Chris answers the questions, if there's anything there that would cause concern or he's confused about, he would have the right to step out again and get a private consultation again. Another alternative is actually to provide a written statement in an interview process. So similar to what we said here, when a company is invited for an interview and they provide written representations, you can do something similar in the interview, where you give a written statement and say, this is my answer to your interview, and I'm not answering any further questions, and that's it. So that's pretty much how it happens. Yeah? I'm glad you guys are still interested in talking about it at 7:15.
Slightly more of a question or a point. At some point in the interview, if he was obviously starting to feel uncomfortable, there was nothing stopping him, as far as I understand, to ask for an adjournment and then say, I wish to terminate the interview at this point because I wish to seek legal advice or have a legal representation. So I think in some ways, maybe in his nervousness, he didn't allow himself to manage the situation and allow himself to be led to a degree, but could have actually taken more control of the situation and just said, stop at this point. I wish to have legal representation rather than perjure himself further.
Yes, absolutely. And that's something that applies to the voluntary type interview, those Section 9 interviews I talked about, and also the interviews under the caution, which this was. He would have a right to step out at any time. He wasn't under arrest. So he could leave at any time. He could stop answering at any time. And he could request legal advice or a representative to sit with him at any time. That means he can just literally say, I'm not answering any more questions until I get that person to sit with me. And that can happen at the beginning of the interview, towards the end of the interview, or somewhere in the middle. Yeah?
You mentioned the working state with your colleagues, and you mentioned you're trying to use Jenny. I felt that he took ownership of it though when he said the word that he would get on with it. And if he had turned it around and said that trying to fish you up, would that have been a rookie mistake? Because that not really was an issue around leadership.
The best way I would say to think about that is blaming. Generally people don't blame each other, I mean, that doesn't happen. But if you're mentioning the fact that this was caused by Jenny or this was caused by me, as opposed to saying, well, it was a board decision to do this, you've got to think about who's got broader shoulders. If they are looking at individuals, the individual is likely to be prosecuted and therefore could potentially face financial penalty and also imprisonment in the most serious cases. If it's a corporate, the most a corporate is going to face is a fine, because you can't imprison a corporate. So generally speaking, the board has broader shoulders, and most often it will be a board decision, because most things are not going to be accepted or passed unless the board approve it in some way. So most of the time it is a board decision. So it probably wouldn't be a rookie mistake to say it was the board, not me, go. But yeah, depends on the circumstances. Yeah. Yeah, we're good. I think that's pretty much it. Yeah, you've done pretty well. I think that's it. So I hope that has given you guys a flavour of what it might be like to be an interviewee. Plus the whistle-stop tour of legal changes in the law. I think there is going to be a better update on the construction issues and more case law in December. Don't wish to step on toes, Nigel, but I know I'm doing one in December, so we'll talk a bit more about CDM and other sector-related stuff then.